Today, we will examine one of the most consequential questions facing American democracy in 2025. Is the United States Supreme Court willing to check Donald Trump's expansive assertion of presidential power, or has it become an enabler of executive overreach? This isn't merely an academic legal debate. The answer will fundamentally reshape the balance of power in American government for generations to come. Let me be direct about what we're witnessing. Donald Trump stands before the Supreme Court today, not just as a president seeking legal validation, but as an architect who helped construct the very judicial body now judging his actions. 3 of the 9 justices, Amy Coney Barrett, Brett Kavanaugh, and Neil Gorsuch, owe their lifetime appointments to Trump himself. This creates an unprecedented situation where a president's most audacious power grabs are being evaluated by justices he personally selected. The numbers tell a stark story. With a 6-3 conservative supermajority, this is arguably the most conservative Supreme Court America has seen in at least 75 years. And Trump's win rate? A staggering 80-90% of cases involving presidential power. Let that sink in. When Trump comes before this court, he wins almost every time. Trump himself has called the tariff case one of the most important cases in the history of our country. That's not his typical hyperbole. For once, he may actually be right. At the heart of this case lies a fundamental question. Can the president unilaterally impose tariffs on any country in any amount at any time simply by declaring an economic emergency? Trump claims a 1970s-era law, the International Emergency Economic Powers Act, gives him precisely this authority. The problem? That law doesn't even mention tariffs. It discusses regulating trade, but Trump has interpreted this as carte blanche to reshape America's entire trade relationship with the world. Here's what makes this so critical. The Constitution explicitly grants Congress, not the president, the power to levy tariffs. The founders understood that taxation and trade were too important to concentrate in one person's hands. Yet Trump is arguing that Congress essentially handed him all of its constitutional authority through vague statutory language. During oral arguments, even some conservative justices appeared skeptical. They questioned whether Congress had clearly delegated such sweeping power to the executive branch. But here's the concerning part. The court has been taking its time with this decision. They expedited the case, held early arguments, stepped in before lower courts could fully rule, and then silence. What does this delay mean? It could suggest internal division among the justices. It might indicate they're struggling to find a legal framework that gives Trump some of what he wants without completely abandoning congressional authority. Or perhaps they're simply being thorough. But the delay itself is telling. If this were a clear-cut case against presidential overreach, we would likely have seen a swift ruling. Trump has made clear his economic agenda depends on this ruling. His tariff policy isn't just about trade. It's about demonstrating that he can reshape the global economic order through executive action alone. A victory here would be transformative, establishing precedent that future presidents of both parties could invoke to bypass Congress on economic policy. Now consider the Federal Reserve case involving Trump's attempt to fire Fed Governor Lisa Cook. This case strikes at the heart of American economic independence and stability. The principle at stake is simple but vital. Can a president fire high-ranking government officials who have statutory protections against arbitrary removal? For nearly a century, Supreme Court precedent has said no. Congress can create agencies and give their leaders protection from presidential whims. This independence is especially crucial for the Federal Reserve, which must make monetary policy decisions based on economic data, not political pressure. Trump doesn't see it that way. Upon taking office for his second term, he immediately fired dozens of officials with statutory protections, including Lisa Cook. His message was clear: I am the executive, and everyone in the executive branch serves at my pleasure. Federal Reserve Chairman Jerome Powell attended the oral arguments in this case, an extraordinary move that underscores its importance. Powell called it, perhaps the most important legal case in the Fed's 113-year history. Why? Because if Trump wins, the Federal Reserve's independence evaporates. Future presidents could fire Fed governors who don't support their preferred economic policies, turning monetary policy into just another tool of partisan politics. The justices seemed nervous during oral arguments, nervous about the global economic chaos that could result from politicizing the Fed. But here's the deeper concern. A ruling in Trump's favor wouldn't just affect the Federal Reserve. It would establish that the president can fire any executive branch official at any time for any reason, dismantling the independent agency structure that has governed America since the post-Watergate reforms. The court has already handed Trump 2 victories involving DOGE, the Department of Government Efficiency. These cases gave the Trump administration access to Social Security systems containing personal data on millions of Americans and allowed slashing of hundreds of millions in research funding for diversity, equity, and inclusion programs. These victories illustrate a pattern. When Trump frames his actions as government efficiency or cutting waste, the court has been remarkably deferential, even when civil liberties and privacy concerns are at stake. The message, if you wrap presidential power in the language of reform, this court is likely to approve. In another recent decision, the court sided with Trump's authority to terminate 2 Biden appointees. The reaction online was surprise. Legal observers hadn't expected the court to go this far in blessing Trump's efforts to purge the government of his predecessor's appointees. This matters because it's part of Trump's broader project, ensuring that everyone in government is loyal to him personally, not to institutional norms or to the Constitution. Each victory at the Supreme Court emboldens him to push further, to test the next boundary, to see how far this court will let him go. Now we come to perhaps Trump's most audacious claim, that he can end birthright citizenship by executive order. The 14th Amendment to the Constitution states clearly, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. This language has been understood for over 150 years to mean that if you're born on American soil, you're an American citizen, regardless of your parents' immigration status. Trump disagrees. He issued a Day 1 executive order purporting to end birthright citizenship for children born to undocumented immigrants. His legal theory hinges on 4 words: subject to the jurisdiction thereof. Trump's lawyers argue that children of undocumented immigrants aren't truly subject to U.S. jurisdiction because their parents entered unlawfully. This argument is legally preposterous. If you commit a crime in America, you're prosecuted under American law. That's what subject to jurisdiction means. The laws apply to you. But Trump's team has constructed elaborate arguments about allegiance and complete jurisdiction that have no basis in constitutional history. Here's what makes this case different. Even Trump-friendly legal scholars struggle to defend this position. Supreme Court precedent from over a century ago directly addresses this issue. And crucially, Congress has passed multiple statutes confirming birthright citizenship. Even if the Constitution were somehow ambiguous, which it isn't, a president cannot unilaterally override federal statutes. Legal experts still expect Trump to lose this case, perhaps 7-2 or 8-1. But the fact that it's even being seriously litigated, that scholarly articles are being written trying to justify Trump's position, that oral arguments will be held, this itself represents a normalization of the absurd. The Overton window is shifting, and what seems impossible today may become plausible tomorrow. To understand where we are, remember what the Supreme Court already gave Trump: sweeping presidential immunity from criminal prosecution for official acts. That decision, issued in Trump's first term, was a radical departure from American legal tradition. It essentially placed the president above the law for anything done in an official capacity. Trump didn't just win that case. He won the principle that presidential power deserves maximum deference and minimum accountability. And he's building on that foundation, case by case, decision by decision. Legal scholars point to Watergate as the relevant comparison. After Nixon's resignation in 1974, Congress passed reforms designed to check presidential power, create independence in government agencies, and prevent future abuses. For 50 years, those reforms held. Trump is systematically dismantling that post-Watergate consensus. He's asserting a vision of presidential power that exceeds even Nixon's most controversial claims. And unlike Nixon, Trump has a Supreme Court that's ideologically sympathetic to expansive executive authority. This isn't just about Trump's personality or his particular policies. It's about whether we're witnessing a fundamental constitutional transformation, a shift from separated powers and checks and balances toward a system where the president, particularly a conservative president, operates with minimal judicial constraint. The Supreme Court's legitimacy is increasingly questioned, particularly by Democrats still angry about the reversal of Roe v. Wade and other conservative decisions. The court is now in play in American politics in a way it hasn't been for decades. Former Democratic operative James Carville, hardly a radical, now openly advocates for court packing. The argument goes, if Democrats win the presidency and both houses of Congress, they should expand the court's size, add liberal justices, and reverse the conservative supermajority. This isn't unprecedented. FDR threatened court packing in the 1930s when the court kept striking down New Deal legislation. He never succeeded in expanding the court, but the threat worked. The court backed down and started upholding his programs. Could Democrats do the same? The next Democratic president with congressional majorities will face enormous pressure from the party base to reform the court. Whether that means expansion, term limits, or other structural changes, the court's composition is no longer treated as sacrosanct. Here's a fascinating contrast. Lower federal courts have frequently ruled against Trump's overreach. District judges and appeals courts have blocked numerous Trump policies, finding them unconstitutional or in violation of federal law. But when these cases reach the Supreme Court, Trump usually wins. This divergence suggests the Supreme Court is an outlier, more willing to defer to presidential power than the broader federal judiciary. This also means the Supreme Court's decisions don't necessarily reflect sound legal reasoning that persuades other judges. Instead, they reflect the ideological commitments of 6 conservative justices who are sympathetic to executive power when wielded by Republican presidents. To be fair, the court hasn't rubber-stamped everything. They ruled against Trump's effort to deploy the National Guard for immigration enforcement in Illinois. They've issued partial rulings against some early immigration policies. These suggest the justices aren't completely captured, but these are exceptions that prove the rule. Trump's overall win rate remains extraordinarily high, and the court's willingness to intervene quickly when Trump wants it to, while moving slowly on cases that might constrain him, reveals where its sympathies lie. What's ultimately at stake is the separation of powers, the constitutional architecture that has governed America since 1789. The founders created 3 co-equal branches of government specifically to prevent tyranny. They feared concentrated power and designed a system where ambition would counteract ambition. But that system only works if the Supreme Court is willing to check the president when he exceeds his authority. If the court instead becomes an enabler of presidential power, the separation of powers collapses. We're left with an elected monarch constrained only by the ballot box every 4 years. Donald Trump understands power in ways that traditional politicians don't. He's not interested in norms or precedent or how things are usually done. He's interested in what he can get away with. And he's discovered that with this Supreme Court, he can get away with quite a lot. The tariff decision, when it comes, will tell us whether there are any limits. The Fed case will reveal whether institutional independence can survive Trump's assault. The birthright citizenship case will show whether even clear constitutional text can restrain this president. But regardless of individual outcomes, the trajectory is clear. Trump is testing every boundary, pushing every limit, and forcing the court to make hard choices about executive power. So far, the court has mostly chosen to let him proceed. The question posed at the beginning remains, will the Supreme Court stand up to Trump? Based on the evidence to date, the answer appears to be occasionally, reluctantly, and only when he pushes so far that even conservative justices grow uncomfortable. That's not the robust check on presidential power the Constitution envisions. It's a court that has decided that Trump's vision of executive authority, expansive, aggressive, and largely unconstrained, falls within acceptable bounds. And that decision will shape American democracy for decades to come, long after Trump himself has left the political stage.